Hello, everyone. My name is Lluc Cerda. I'm a managing partner here at Samfiru Tumarkin in the Calgary office. I'm here today to conduct this employment law question and answer period. We're here to try to answer as many of the questions that you have on your mind related to work. Anything you have related to work in terms of legal questions, put them in the chat. We're trying to get through as many of them today so that you have the answers you need. So I'm also the employment practice lead for Western Canada at Samfiru Tumarkin, and can answer questions related to BC law, Alberta law, and of course Ontario law as well. So feel free to put your questions in the chat. We're going to get to as many of them today as we can. We have a question coming in already. Here we go. Let's get started. We have a question coming in from Mang Lee on YouTube. Mang is asking, I was verbally told on April 18th, 2024 that I would be laid off or terminated. I have not received anything formal from the employer, and I'm currently still working there. Meng continued, the employer has verbally told me that they want me to leave on May 31st, 2024, and would like me to sign a mutual release before that date. I'm not leaving or calling an employment lawyer until I receive the mutual release documents or a termination letter. Is a mutual release considered a termination letter? Do I continue going to work after May 31st, 2024 as usual until I receive a termination letter? Great question. Meng, unfortunately, you're put in a position that you don't know what's heads and what's tails here. Your employer has told you verbally that your job is going to end on May 31st, but you don't have anything in writing. And of course, termination has to, in most cases, be written. All right. Now, a verbal termination can potentially count as a sufficient notice of termination, but really, at some point, you're going to need something in writing. So what the employer is trying to do here by telling you on April 18th that your job will end on May 31st is they are trying to tell you, listen, be prepared, your job is coming to an end. In legal terms, what that's called is working notice of termination. So notice of termination is what's colloquially called severance, all right? So when you're severed from your employment, you're entitled to a certain amount of months of compensation to tide you over into when you find a new job. Now, the employer, instead of paying you cold hard cash, can also tell you, well, listen, your job is going to end in a certain amount of months, but I expect you to come in and work during that time, but you now know that your job is going to end, so you may as well also use that time to try to find a new job. That's totally legal. So that's where we have it. What I would tell you, Meng, I don't know much about you in terms of how much severance you would get, and if the amount of working notice that you're being provided is adequate or not. Usually, there are four main factors that we look at to determine how much severance you might be owed, which are your age, your length of service, the type of job that you held, was it a senior role or a more junior role, and the availability of similar work given your circumstances, such as your education, your location, things like that. Now, what you can do right here now today, Meng, is that you can also use our severance pay calculator that we have available for free to anyone in BC, Alberta, or Ontario. You can find out how much severance you might be owed. And to find that severance pay calculator, simply visit our website, which is pocketemploymentlawyer.ca. We have it up here on the screen. Anyone who's listening today who's wondering, well, actually, how much severance am I owed? Just go onto that website. We ask you 4 questions, no obligation, no commitment from you. Just get the information that you know how much we're talking about here, because it can be substantial. It can be up to 24 months of severance, 2 years of compensation. So it can be a substantial amount. But I think what you need to know, Meng, is unless you're a very short employee, and even then, I think that a month and a half of severance is going to be a very low amount of severance, and that you're likely entitled to more severance than what the employer is providing. So it could be one of two things. They could say, well, here you are, you've had a month and a half of working notice, sign this release, that's all you're going to get. Or they might give you a termination letter towards the end of that working notice period saying, well, this last 6 weeks counted as working notice, but we understand that we owe you more than 6 weeks. We think we owe you, I'll just put a number out there, 20 weeks. So we'll deduct the 6 weeks we've already paid you from the 20 weeks you're owed. Here's another 14 weeks that we're willing to pay you if you sign this release. So that's how it typically works, and that's where we typically get involved. You're right, Meng. Before you sign the release, make sure that you reach out to us. Make sure that you visit the pocketemploymentlawyer.ca website, figure out how much severance you might be entitled to, and then we can discuss, you and I, how we go about getting you that severance. All right, and it's generally by letting the employer know that we won't sign that release until the amount that you're getting for signing that release is closer to what you're actually owed. All right. So if you have any questions related to that process, feel free to reach out. You can reach out to us directly here at employmentlawyer.ca. That's another website, employmentlawyer.ca. If you want to reach out, have us review your severance package, any release that comes with it. But understand, if you sign the release, then you can't get more after. So it's very important you make sure you are happy with what you're getting when you sign the release. All right. So that's usually when the lawyers come in and become involved to make sure that you're getting a fair amount. Because once you sign the release, it's very hard to undo that release. And I see people every day that are like, I felt pressured. I signed the release. They told me they'd revoke the package if I didn't sign the release. It's important you take your time. This is an important financial decision, right? You wouldn't make a financial decision worth tens or maybe hundreds of thousands of dollars on the spot regularly. You shouldn't do it when it comes to the end of your job either. All right. So make sure you put in the time and effort to understand what your entitlements are before you sign that release. Because once you've signed it and given it back to the employer, it's much too late to go back and ask for more. All right. So keep that in mind. We have another question coming in from Ulrich. Ulrich asks, warehouse employee on STD can no longer work at old job and cannot be accommodated into another position due to sore back. Does this fall under frustration of contract? And if so, does it adversely affect severance pay? All right, so a few points. So frustration of contract, let's just start with that. So frustration of contract, what that essentially is, for those of you who are not familiar with the term, it means that it's not that the employer doesn't want to employ you, and it's not that you don't want to work for the employer. It's just that there's something that's intervened that prevents that from happening. And in this case, what we're talking about is a disability. All right. So if a disability prevents you from working, and it's prevented you from working for a substantial amount of time, and there's no likelihood that you can return to work even with an accommodation for the foreseeable future, that an employer may tell you, well, listen, we want to employ you, but you're never coming back, or you're not coming back for the foreseeable future. We can't keep your position open much longer. So we're going to terminate your employment relationship, and we're going to claim that it's due to a frustration of contract. Now, what's important to know is when your employment is terminated due to a frustration of contract, that's really, in the eyes of the law, no one's fault. And because it's no one's fault, you don't have to provide notice of resignation, and the employer doesn't have to provide you with severance. All right. Now, because it can drastically affect your severance entitlements, the law takes a close look to make sure that, in fact, this is truly a case of frustration of contract. So you're going to have a lot of trouble finding cases that say that frustration of contract arises prior to 2 years of long-term disability. All right. So Ulrich here is mentioning short-term disability. I would say if you're still on short-term disability, you're still in the 6 months following the beginning of your leave. I would say it's very hard to prove in 6 months that you're going to be completely unable to return in the foreseeable future. Things need some time to develop. Therapies need some time. Different treatments, appointments with specialists, all that takes time. So it's very hard to say, in the first 6 months of your disability leave that amounts to frustration of contract. So Ulrich, right there, if the employee is still on short-term rather than long-term disability, that's a red flag for me that it's probably not frustration of contract. Secondly, so we're looking at, potentially at least 2 years of disability before you can start claiming frustration of contract. And even then, what that means is that the employee cannot return to work even with accommodation for the foreseeable future. So, which means that if the employee can return to work with an accommodation, then there's no frustration of contract. The employer has an obligation under human rights legislation to accommodate that employee in the workplace. A bad back, for instance, might mean no lifting over a certain amount of weight. It might mean not too much time on your feet or not too much time seated, things like that. So that can be easily accommodated in most workplaces, all right? If, however, it's a fundamental duty in the job description that you must be able to lift above a certain amount of weight, above 10 or 20 pounds or kilos, and then you can say, well, listen, this job can't be done unless you have that capacity to lift that weight. So potentially, in that case, then yes, you can say, well, it would cause me undue hardship to modify the job description to allow this person not to lift above a certain amount of weight. I don't have a lot of information on everything that goes into this, Ulrich, so I'm kind of setting out some parameters of what might be looked at. But then, as I mentioned, the third part of your question, it does impact severance. If you can establish that there is frustration of contract, under common law, you lose your right to your full severance. Okay, so you would not get severance in that situation, except in Ontario, where you would still get your minimum entitlements that you're owed under a law called the Employment Standards Act. All right, so that can be up to 35 weeks of termination and severance pay. So it's still substantial. It's up to 7 weeks, 7 months rather, of pay. But for someone to get 7 months of pay, they probably, if they were just being terminated without cause, be eligible for up to 24 months of pay. So it is a big reduction. And in Alberta and Ontario, you actually don't get anything else. So I hope that answers your question. But what I would tell you is, if you're thinking that this person is on STD, it's been less than 6 months that they've been disabled, I would struggle to argue that this is frustration of contract. You need to give it a bit more time. We have another question coming in from Arch M. Arch M is asking, if you are moved informally into a new position taking over for a previous manager, should you receive a new contract and pay increase? All right, so we've said this a lot over the last few shows. Do not go around begging for employment contracts, okay? Arch M, I'm happy you got a promotion, but employment contracts are there to protect the person who drafted the contract, all right? And who drafted the contract? It's going to be the employer. So the employer is going to protect for themselves as many of the rights that they can get to you to agree to in a contract. So they might get you to agree to a termination clause, which would limit how much severance you're owed if you're terminated. They might get you to agree to a non-competition clause, which might limit your ability to look for new work. If you all of a sudden become a superstar at this manager role, you might have recruiters, kind of coming in saying, well, listen, come work your magic at our business, and we'll give you a nice, bump in pay. But now you can't because you've signed a non-compete agreement, a non-solicitation agreement. You might have, a number two that you'd love to take with you where you go. Now you can't recruit that person. You might have start developing client relationships that, really bring in a lot of revenue that you can't take with you when you leave. So all these things really impact, the end of your employment and get dealt with in an employment contract. So if you didn't already have an employment contract, don't go around begging for one now. The fact is that we all have employment contracts, whether we have the written or unwritten. All right, contracts surround us all the time. Every time you go to the corner store to buy a piece of gum, you've entered into a contract. All right, believe it or not, in the eyes of the law, there's always a contract there. The contract is an oral contract, or it's not a written contract, but there are still obligations that both buyer and seller understand that they have. All right. So even though there's no written employment contract, we know that you've been promoted. We know that you have certain job duties because you're doing them. we know that you're getting paid a certain amount of pay because you're getting pay stubs showing that that's what you're paying. We know how much vacation time you have because that's how much vacation time you took last year. All this stuff is known. It doesn't have to be written into an employment contract to be able to prove that these were the terms of your employment. All right. Now, one thing that a lot of employees like having is a list of job duties. If you think that that would be important for you to know what your job duties are, just ask for that. Just, can you, boss, tell me what my job duties are going to be in this role? All right. Job duties are especially important maybe in unionized situations where people don't want to do stuff that's not in their job duties because it's somebody else's unionized job to do that, and they don't want to step on any toes. If you're a manager, you're kind of a jack of all trades. You're going to go where you're needed, right? So keep that in mind, right? But generally, as a manager, you should be doing managerial job duties mostly, right? We have a lot of situations, for instance, Starbucks store managers are nominally managers, but they're on the tail or brewing coffee just as much, or if not more, than their baristas, right? So that's not a true manager. So that's where it would be important to know what the job duties, the formal job duties are, to understand if you're even a true manager or not. But generally, in an office setting, right, you're going to have reports and stuff like that. Get the job description if you want, the list of job duties, that's great, but don't go chasing an employment contract. Should you get a raise? So there's some things that the law doesn't get involved with, all right? So some aspects of business, the law says, guys, figure it out on your own. So I personally think that if you take on more responsibility and a more senior role in your job, that you should get a pay raise, absolutely. But there's nothing in the law requiring the employer to give you a pay raise. So it really comes down to what the parties are able to negotiate amongst themselves. So definitely, I think it's appropriate for you to ask for a pay raise. But you can't turn to the laws to say, well, listen, this is what the law says managers should be paid. I'm a manager, pay me that. It's not like that. The only really set amount of wages that is required by law is the minimum wage. Anything above that is up to the parties to come up with on their own. Mengli is following up, asking, does a mutual release count as termination? Can they keep me? So a mutual release, listen, what counts as a termination is them telling you don't come into work. So that's usually put in a termination letter. A mutual release settles any disputes that arise from the termination, okay? I would tell you, Meng, do not sign a mutual release until you've received a termination letter outlining what your employer's severance proposal is and having it reviewed by us. And again, to reach out to us is as easy as going to a website called employmentlawyer.ca. Visit employmentlawyer.ca. It's up 24 hours a day. We're going to be able to help you make sense of all of this. The mutual release, though, once you sign that, you can't do anything about the fact that you've been terminated. You have agreed to forego any rights that you have to additional severance, save any amounts promised in the mutual release or any amounts that would be owed under employment standards legislation, which are really minimal amounts and that you'll probably get paid anyways. All right. So the mutual release is the important legal document in your termination package. Once you've signed that, you can't go back and ask for more. So definitely, if you're thinking of signing that, make sure you talk to us first. Make sure you're getting a fair amount of severance. And that basically the severance you're being paid, one way to look at it, is the employer is paying you all that money to get you to sign that release. Okay? So that's a very expensive piece of paper in the eyes of the employer. All right, that piece of paper is very precious. It's worth a lot of money to them. So you should make sure that you're getting an appropriate amount of money for signing that release. Okay, so be sure to get some legal advice. Be sure to contact us before you sign that release. All right, and if they're saying, well, we allowed you to work for 6 weeks, can you now sign this release? I would tell you, Meng, don't. Just don't. All right. You can just not sign the release. What are they going to do? claw back your pay. You worked that time, you're owed that time anyway. So definitely don't give them a release for absolutely nothing. Okay, so don't sign that release would be my advice until you've spoken to us. We have a question from Harris Khan. Harris is asking, how important is the fairness of procedures in the termination process, and specifically right of hearing in the termination process? Thank you. So, Harris, what else? Before I answer that, I'm just going to start by saying there are generally two ways to be terminated. One is for cause, which means that you've been found guilty of some type of misconduct that allows the employer to say that they're terminating you for the misconduct that happened, and because it's based on your misconduct, you're not entitled to severance. For cause termination. On the other hand, we have without cause. All right, so there might be a reason why you were terminated, but the employer is not relying on that reason to deprive you of your severance. All right, so the reason might be, drop in business, restructuring. Maybe they aren't happy with your performance, or you've done something they're not happy with, but they realize it doesn't rise to the level of severity required for a just cause termination. So they're just like, you're not a fit, whatever. Here's your termination letter. Here's your severance package. All right. So that's a without cause. All right. And that's the vast majority of terminations are without cause terminations. All right. So when it's a without cause termination, there's no right of hearing. It's no one's saying you did anything wrong. It's not your fault that you're being terminated. It just needs to happen. It's a business decision by the employer. There's no procedural right for you to argue your case that you shouldn't be terminated. If the severance package is sufficient, the employer is allowed to terminate you. So really all that the law is interested in that case, in a without cause termination case, the only real legal question is the severance that is being offered, is it adequate? And if it's not adequate, then let's argue about what is the adequate amount, but not, whether the employer was allowed to terminate you or anything like that. It's just, is the severance package enough? Without cause, they're saying you did something wrong. So yes, there is a requirement. It's not a black and white requirement that you need to be investigated, that you need to be given an opportunity to give your side of the story. It's not that there's a black and white requirement that they do that before they terminate you for cause. But obviously, if they don't do that, it's going to be harder for them to prove that they had just cause to terminate you. Because you can also, the law in that case is interested in knowing whether the employer actually had sufficient cause at law to terminate you. And if they didn't have sufficient cause at law to terminate you, then your for cause termination will become a without cause termination and you're owed severance. So in a for cause termination, the law is really interested in knowing, was there cause? And if not, how much severance is owed? All right. So employers who are taking their job seriously will give you an opportunity to respond to the allegations. Employers who don't know the law or don't care about the law may not conduct an investigation and are really torpedoing their chances of proving that they had just cause to terminate you. All right. But is there a legal requirement that says you cannot terminate anyone in any circumstances unless you've given them a fair hearing? That doesn't exist, unfortunately. It just complicates the employer's job to prove that they had cause because they just did a sloppy job of the termination. All right. So that's my view on that. So what I would tell you is we are often quite successful in quite a lot of cases in having a just cause termination overturned and resulting in a finding that the employee is owed severance. So if you've been terminated for just cause, that's not the end of the story. That's really the beginning of the story. You should reach out to us, explain to us what you understand is the reason why you were terminated. We can let you know whether that amounts to just cause at law or whether you might be owed a substantial severance. So if you want to reach out to discuss a recent just cause termination, reach out to us at employmentlawyer.ca. All right. Next question here we have from Stacy McDonald. Stacy asks, what if you require accommodation to the bullying, harassment, and discrimination from the CEO? So Stacy, what I would tell you is usually accommodations are discussed in the human rights context. And so in the human rights context, accommodations are often discussed when someone is alleging that they have a disability that needs to be accommodated. So if you're the victim of bullying and harassment from the CEO, to get an accommodation, you would have to have a disability of some sort that requires accommodation. And how do we know whether you have a disability and whether that results in restrictions that need to be accommodated? Your doctor tells us. Your doctor writes a note saying, Stacy is unable, for instance, to work from the office, whether it's due to, bullying and harassment or some other reason. Stacy must work from home going forward. This is a, permanent, temporary restriction. And then the employer decides whether they can accommodate that restriction. For instance, I'm just putting something out there. If no disability flows from the bullying and harassment, if you're not, having a mental health crisis or anything of that nature, doesn't mean that you have to just accept the bullying and harassment. You, in fact, all employers in BC, Alberta, and Ontario have an obligation to have anti-harassment or harassment in the workplace policy. And the harassment in the workplace policy does a few things. It defines what's harassment in the workplace, and it talks about everyone's roles in dealing with harassment. So your role would be to make a complaint, to raise the issue with someone in authority to investigate. All right. So that gets complicated when the respondent, the person, the harasser in this case, is the CEO, right at the top of the chain. But most policies, most well-drafted policies, should be able to address that. If, for instance, your immediate manager or someone else that you would normally report harassment to is the harasser, how do you go about that, right? And there should be something in the policy. So what I would tell you is start by looking at the policy and firstly determining whether there's a policy, and if there is a policy, whether it explains a procedure for making a complaint against someone who's in a position of authority over you. All right. If there is no policy, then you can make a complaint to the Ministry of Labor's health and safety officers that will force the employer, and you can do that anonymously. Then the health and safety will go in, check, is there a policy? No. Go ahead, employer, draft a policy. You need to have a policy within 30 days, for instance. And then once the policy is in, review it. If it gives you a procedure to complain about the harassment, then go ahead and follow those steps. And it'll be investigated. We have another question coming in from Smashley. Smashley is asking, worked 10 years as a contractor for a local production. They said sales are down and they won't be renewing a number of contracts for the next year. Are contracts workers owed any severance? All right. I think we saw the word contract used in two legally different scenarios there. So I just want to make sure that we're talking about the same thing. So there are people who are contractors. Imagine, you hire someone to come and renovate your bathroom. That's a contractor. That's usually called an independent contractor. All right. And then we have people who are on fixed term contracts, also known as seasonal contracts, who are employees. They're not independent contractors. They're employees, but there's an end date to the contract that they're working on. So instead of being like most employees hired on an indefinite term, they're hired for a fixed term. They're saying, well, this is a maternity leave replacement. We need you only for a year. Okay. So in terms of independent contractors, truly independent contractors, you usually don't have to give them severance when they're terminated. Because of that, a lot of employers misclassify people who, in the eyes of the law, are employees as independent contractors. They'll say, well, listen, I don't want to pay you, make source deductions, make EI contributions. I don't want that. I want you to send me an invoice. I'll pay the GST on your invoice. You take care of your own taxes. You take care of all of that on your own. I'm going to treat you as an independent contractor. Now, you have the right to have the law determine whether you are in fact a contractor or whether you're more like an employee, all right? And that goes a lot deeper than just looking at, the kind of contract that you sign when you started working, the way you do your taxes, the way you do your invoicing and all of that. That's going to be looked at, but there are other more important things that are looked at. Basically, the fundamental question that the law is looking at is, are you truly in business for yourself, the way an independent contractor who renovates bathrooms is? They have their own truck with their own company name on the side. They have all their own tools, and they do, 15 to 20 bathrooms a month, right? Not all of those 15 to 20 homeowners are their employers. They have no employer. They're their own boss. They're in business for themselves. On the other hand, you have people who are part of a larger organization. Even though they're called contractors officially, clearly they're working for somebody else. They're working for an employer, right? So theoretically, it's not very hard to imagine that generally any job could be called a contractor, right? And I've seen it. I've seen senior vice presidents of corporations be called contractors. It makes no sense. You're working for a corporation as a contractor. So if you are able to convince the law that you are not a contractor, that you are an employee, and you've been there for 10 years, you're owed severance. Yes, absolutely. Okay. If you've been on a series of fixed term contracts for 10 years, then likely you are also owed severance. All right. So what I'm trying to say is that, yes, potentially you are owed severance if you're terminated from this job in the coming months. So best thing to do is to contact us, because we need, like I said, right, just using the word contractor is not enough. We need all the background. So reach out to us. We're at employmentlawyer.ca. We'll let you know whether you're, truly an employee and truly a fixed term employee. And therefore, we can talk to you about what your severance entitlements might be if you're terminated. Guys, we've gotten a great turnout today. So great that I might not be able to get to all the questions that are left. I'm going to answer. I have 4 more questions here. I'm going to answer them all, and then that's going to be it. But thank you for getting all these questions, and you've been very responsive. I appreciate that. We got Faizul Arfin is asking, is there a litigation for religious discrimination in the workplace? Absolutely, Faizul. It's a protected ground under all human rights legislation in BC, Alberta, Ontario, and the federal government as well, and the federally regulated employees as well. So yes, if you're the victim of workplace discrimination due to your religion, then yes, you would in BC, Alberta, and for federally regulated employees, you would have to go through the Human Rights Commission and then on to the Human Rights Tribunal. You have that option also in Ontario. You can also go through the courts in Ontario if that's what you prefer. We have a question, from Harris Khan. Harris is asking, how important is the fairness of procedure during termination? I think Harris asked this question earlier. Oh, yes. Okay, here we go. Harris Khan, how important is fairness of procedure during termination process, and specifically giving right to hearing during termination? So I answered that question earlier. What are the consequences of denying that right to the employee? And I mentioned that earlier. Okay, so basically the employer will have trouble proving that they had just cause to terminate you. We have Jordan Christie asking, how do EI entitlements affect calculation of severance pay? Well, the short answer is they don't affect the calculation of severance pay at all. What does end up happening is that you can't get severance pay and EI for the same period. So you're terminated, your employer, just to use a number, offers you 8 months of severance, and you accept it. What that means is for 8 months, you'll have your severance, but you can't apply for EI. And then once the 8 months are done, if you still haven't found new work, then you can apply for EI. and you're entitled to your whole EI, whatever you've accumulated up to then. What sometimes happens, so that's the how that works, all right? What sometimes happens is people come see us, they haven't been provided with severance or with enough severance, and then we get them the severance they're owed, but they were able to, during that time, get EI, all right? So you might have to repay something to EI. So imagine a scenario, you're terminated for cause, for instance, you provide them no severance, EI looks at it and says, this is not cause, we're going to give you EI. And then we get involved, and this is not cause, and we get you 8 months. And say that took 2-3 months to happen. So you got 2-3 months of EI. You have to pay back what you receive for EI for those 2-3 months from the severance that we got for you. Okay. Doesn't mean that 2-3 months is lost. Okay. That means that, say your EI entitlements was for 12 months of EI, you've paid back 3 months. And then you'll get that 3 months at the end if you're still unable to find new work after your severance period when you go back onto EI. So it's not lost unless you find a new job, but it's not, your entitlements stay the same. And our last question for today is from Tahir Afridi. Tahir asks, how do we determine years of service to consider? For instance, let's use this case. Employee migrated to Canada 5 years ago and signed a Canadian contract with the same company he was working for in another country for 3 years. All right. So generally, recognition of years of employment, I had this come up recently, actually. The situation was that an employee came to work for a sister organization. So, in the eyes of the public, it was the same company, but in fact, one was incorporated in Canada, one was incorporated abroad, and so they weren't the actual same legal entities, all right? They were sister companies, all right? And essentially, there's enough between those two companies that their years of service between them should count when coming up with termination entitlements. However, when you join the new company here in Canada and they ask you to sign an employment contract, this is why I tell you guys, don't beg for an employment contract, because they sneak stuff in there. So what they can sneak in there is saying, well, we are not going to recognize your years of service in sister company abroad, right? And if you sign and agree to that, it's very hard to undo that, right? It's very hard to say, well, actually, I agreed that my years of service would not be recognized, but here I am arguing that they should be recognized. Because really, when you're looking at should years of service be recognized, you're looking at what was the intention of the parties, right? And you can tell that sometimes by, for instance, you had 5 weeks of vacation abroad. Here, the minimum you're owed, and everyone who starts in Canada gets 2 weeks, but they keep the 5 weeks, might be an indication that they saw you as a continuous, your employment as continuous. But here we have black and white that they're saying, we are not considering your employment continuous. You went ahead and signed that. Hard to argue. So generally, what I would tell you to hear, absent that in a contract, you're looking, the law is looking, had the parties asked themselves this question at the time of starting the new contract in Canada, what would the answer have been? And it's hard to answer that question, but there are sometimes some indications. For instance, we often see someone who's worked, say 3 years abroad and then 7 years here, and all of a sudden they get a 10-year anniversary plaque. Seems to me that they're recognizing the 3 years abroad, right? Or they get started on benefits right away, or there's no probation clause when they start here, right? That's the kind of clues that you're looking for to get a sense of what the parties would have answered had they been asked the question at the time that the job was transferred to Canada. All right, everyone, thanks for signing in. We went a bit long, but we had some great questions, and I wanted to get to all of them today. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin. I'm the Western Canada Employment Practice Lead for Samfiru Tumarkin. We have another show coming up tomorrow, I believe. Yes, we do, with my colleague Martin Willems. He'll be here to answer your disability law questions tomorrow starting at 10 a.m. Pacific time. So feel free to make sure to join. And thank you for joining us today. Great questions as always, and we'll talk to you soon. Bye now.